Hi everyone, my name is Simon Mishevich from Optimised Accountants, and in this video we're going to be talking about stamp duty, land tax, mixed use property, and a case that HMRC have won. It's not an obvious case where you blatantly say that whatever the evidence was, that it's clear and obvious. There are some details behind this. I want to go through mixed use properties, what it is, what you need to be careful of. Okay, so let's go through the details. If you want an online tax calculator for stamp duty, land tax, or anything else for that matter, then feel free to use our website. The QR code is appearing in front of you just now, or indeed there's a link in the description box below. What is HMRC's standpoint on mixed use properties? And it is basically you pay stamp duty, land tax on increasing portions of the property price or consideration when you pay £150,000 or more for non-residential or mixed, also known as mixed use land and property. And we've got some examples what they might be. We talk about flats above a shop, that kind of thing. Now, when we talk about residential property rates, we have to think about the banded rates of 0 to 12%. You also have the 3% SDLT surcharge if you're buying a property in your own name and it's your second property, or if you're buying in a limited company. And you got this extra charge of 2% if you're a foreigner as well. If you are a foreigner buying property, then make sure you get the best currency exchange rates using that QR code just shown there. All right, so if you're buying a property, then you need to be aware residential, you have this banded rate on the left-hand side, the 3%, which is the surcharge for buying multiple properties in your own name, or indeed buying one property in a limited company or more. And then you have the 2% foreign. And as you can see, the rates can be quite high. You could be paying 15%, 17% stamp duty land tax, which is quite significant. Now, when you have non-residential property, then your rate is only 5%. So it's a really good opportunity for you to buy properties that is mixed use. Again, examples being a flat above a shop, which is what this is suggesting, in fact. You may have a home on land with offices. You may have one title that's got both residential flats and it's got flats, offices as well, which combined makes them mixed use, which is non-residential rates of SDLT. So really good. And you could have agricultural buildings, paddocks, leased land, all of that. And we saw a court case where HMRC lost, where there was a paddock and the rates was non-residential rates, not the residential rates, which HMRC tried to impart. There is a video I've done for that, so have a quick search for it. But this is where HMRC won a court case with mixed use properties. And the situation was, as you can see the court case there, so feel free to have a look at that yourself. The taxpayer acquired 3 property interests at the same time. A leasehold flat, a share of the freehold in the property, and which the flat was situated, and 3 lock-up garages. So you got the flat, the freehold in which the building was in, and then separately to all that, you've got these lock-up garages, which was physically detached from the flat, but only 3 meters away. So it's remote. And what was happening with that? Well, could it be leased out, rented out for commercial purposes? And that's the purpose of this, isn't it? Is to say, well, actually, if it's similar to the paddock which HMRC lost that court case, these are 3 garages and it could be rented out for commercial reasons. Therefore, could this whole thing be non-residential rates? And that's what you would always go for. However, HMRC said the garages had separate legal title. They had been used informally for storage, but at the time of purchase, planning permission had been granted for them to be demolished as part of a plan to redevelop the property. So the whole thing may be coming down. And that's where HMRC hung its hat to say, well, this is therefore residential. There isn't any agreement to do anything commercially with these. It's to create residential properties. Furthermore, it says the taxpayer relied heavily on the fact that separate land interests had been acquired, which is the 3 garages. But the tribunal said that the key question was whether the garages and interest in the communal garden were part of the main subject matter. So was you buying this because they are such a good deal, or was you just going for the flat inside the freehold? So they're saying of that transaction, the independent subject matters in their own right. In deciding the former, the tribunal therefore conducted that the mixed use rules did not apply, and the whole purchase was subject to stamp duty land tax at normal residential rates. And what we have to look at here is what is the perspective? Because if we look at the previous court case whereby you have this building, you've got this separate paddock which is going to be leased out commercially. What's the difference between that and this, which HMRC lost that case but won this case? And what they really are saying is, well, is it commercial? Is it long-term going to be rented out to someone else, third party, which is a commercial arrangement? Or is it just storage, which if it's storage, part of your own residential home, well, it's still residential. The fact that you got three doesn't matter. It's still residential. You could have easily acquired these garages separately. And that is the point, because those was going to be part of a redevelopment, and therefore HMRC was saying, hey, this whole thing is residential. The fact it's being redeveloped does not matter. It's part of your flat and part of the freehold. Nothing else really matters. The court agreed. It'd be interesting to see what you think of that court case, because I think it could have easily gone the other way as well. But you know, this is a classic example whereby the devil is in the detail. And sometimes you just don't know where the court will decide to take this. So make sure you get some careful tax planning whenever you're using the mixed use property rules for reducing your residential stamp duty land tax rates to non-residential rates.